We're Dr. Shield, and we do insurance differently than most companies. Things like simplifying details so it's easy to understand what makes us Malaysia's most innovative indemnity provider. As a Dr. Shield client, you'll enjoy comprehensive coverage with fewer exclusions. With some insurers, you'll only find out what's not covered when you make a claim. Our policy details are online and easy for everyone to understand. Competitive premiums that don't keep increasing. Many insurers increase their premiums across the board to compensate for losses. Dr. Shield limits the number of doctors insured from high-risk categories, so our premiums start fair and stay fair. Prompt dispute resolutions. We're pro-mediation because settlement and negotiation, instead of endless litigation, is better for everyone. Career and reputation protection. Typically, litigation can drain a doctor financially and emotionally. We limit the damage by both, so our clients emerge good names intact. And peace of mind, because a happy doctor is a good doctor. Our different approach to creating policies means we put you first, before us, so you can enjoy your career and sleep like a baby, even if you've just delivered one. Dr. Shield, insurance with a difference.
Welcome everybody to our latest webinar. It's the monthly medical legal talk brought to you by Chubb and Dr. Shield together with DOBBS. And I am honored today to introduce our speaker, who is Datin Anit Kaur Randawa, who is an advocate and solicitor and partner with Asbir Hirasing and Company. And the topic which she will be delving on is something which is extremely important to all of us who practice medicine, and that's the issue of documentation. So, what should we document or what should we not document? And that is the pertinent question for tonight. Before we dive into the talk, I just want to go through some housekeeping notes. One is we'll take Q&A after the talk, and preferably using Slido. If you can use your normal camera or QR code scanner application, and then it will take you to slido.com at this event code, which is 3693980. If you're watching on your laptop or iPad on our Medicolegal CME webpage, which we shared on email and in our forum, you'll see the Slido questions embedded below the video. All right. And I just want to take the opportunity to ask those of you who have not subscribed to our YouTube channel, please do, because that's one way of keeping you updated on what's coming up next in our live stream. There's another channel which I'd like you all to subscribe to or follow us, because we'll post these upcoming webinars as well in our WhatsApp channel. So the shortcut to the WhatsApp channel is dobbs.my/WA updates. So you open this in your browser and it will redirect you to your WhatsApp app, and you'll see our channel, and please follow us there as well. So I'll appreciate that, because it's very hard to keep you all notified of what's updated, and as there's so many thousands of you in the forum. So not all of you visit our Facebook or Telegram groups regularly, but if you subscribe to either of these, and at least is another way to keep you informed. Okay, now the CPD points will be awarded at the end of our the Q&A, and we'll post the info on how you can claim your points. All right, so anyway, without further ado, I'd like to now present the talk by Datin Anit Kaur. All right. Stay tuned.
Good evening, everybody. Thank you for joining us, and thank you for the organizers for inviting me again to speak on a topic that actually is inspired by some medical interns who came and sat into one or two of the trials that I was conducting over the past 2 months and gave me this insight about how they thought the level of documentation that was required and cross-examined in court about was just something beyond them, and they were not told about this when they were doing their medical degrees. So as inspiration to them, and perhaps if they didn't know, this was something that we thought was a topical issue which should be addressed again. So the topic today is to document or not to document. That is the question. Okay, so my talk today will have a short introduction, and then I would dive into what it takes to keep medical records, the role of medical records, and the effect of medical records in medical legal matters and complaints. And then I'll conclude with final takeaway. Okay. I don't know how many doctors would have read this, but this is in the Code of Professional Conduct that is issued by the Malaysian Medical Council and sent to all doctors. So paragraph 1.1.1 actually spells out the primary duty of the doctor, because it says the public is entitled to expect a registered medical practitioner to provide and maintain good standard of medical care, which includes conscientious assessment of the history, symptoms, and signs of any patient's condition, sufficiently thorough professional attention, examination, and where necessary, diagnostic investigation. Also requires competent and considerate professional management, appropriate and prompt action upon evidence suggesting the existence of a condition requiring urgent medical intervention, and readiness, where the circumstances so warrant, to consult appropriate professional colleagues. So this is the standard of practice that has been laid down by the Malaysian Medical Council that governs all doctors in Malaysia. And so if there is at any point any complaint or any suit, what usually happens is they complain to the Medical Council, they'll assess you by these standards. And then how would you prove that you have lived up to these standards? That's the question. Now, Malaysian Medical Council also has issued quite a few other guidelines. Some of those guidelines are on confidentiality, on organ transplant, on telemedicine, and there is also a very, very significant guideline on medical records and medical reports. So as far as documentation is concerned, the medical records guidelines actually apply. And I have actually picked out parts of those that are actually relevant to the issue of documenting in medical records. So firstly, there's a definition. A medical record is a documented information about the health of an identifiable individual recorded by a practitioner or other healthcare professional, either personally or at his or her instructions. That would include a nurse, an assistant nurse, and it should include sufficient information to identify the patient, support the diagnosis based on history, physical examination and investigations, justify the professional management given, record the cause and results, and ensure that the continuity of care provided by the practitioners and other healthcare workers to that particular patient. So medical records are also historically regarded as aid memoirs. These are words from your guidelines itself for physicians treating patients as essential components to patient care. They contain information about the patient on one part, the physician's opinion, clinical judgment brought upon to bear on the patient's management on the other part. So, excuse me, in a nutshell, it's an understanding that it's an essential tool that is created by a practitioner or other healthcare professionals and evolved into a concept that this is going to be the contemporaneous record that is belonging to the physician and also the patient and retained by the physician in the place of practice. So what are medical records? You have two types, manual and electronic. I know a lot of people, including general practitioners these days, who have moved towards electronic medical records. But generally, it always started with manual medical records, which were kept by a doctor when the patient came in. Patient was clocked. Patient would be clocked by whoever was registering the patient. Then the doctor who would see the patient would then document in the course of engaging with the patient the kind of history that was told to the doctor, any investigations carried out, and any findings and any options for treatment given, if at all. With advancements of technology, you have the electronic medical records. Now, those have emerged as the more prominent ones, but there are also challenges regarding their security, accessibility, and assurance of patient confidentiality. A lot of big centers have already overcome all that. But for me, as a lawyer, I find that with electronic medical records, they are very time specific, very date specific, and entries that are made later are always reflected because it actually has the time when you log in, the time when you log out. So if you have logged in at a different time from what was said to have happened, that would be a challenge on which was correct, the medical records or the version that was given. But this becomes very specific. So things like a call was made, blood was taken, what time the group and cross match was asked for, how long it took for it to come back. All these are clocked electronically. Previously, they were manually, and there's room for errors. But with electronically, it captures it. And if you come and make any late entries, the system also captures it. So in preparing these medical records, all medical practitioners must keep in mind that they're generating a document. While it may reflect the personal findings of the doctor, it can be demanded by the patient at any time in the court of law and in matters of litigation, as well as medical counsel proceedings. This is a slide I use quite often when it comes to manual medical records because doctors are famous for having very, very illegible handwriting and having had to look at it all the time. There are times where it is such a pleasure because you see it written very clearly and you can understand, but at other times it is quite illegible. But it's a valuable document in patient care, so it may be read and disclosed. So therefore, it must be completely objective, comprehensive, and legible. And if at any time it's illegible, lawyers would always say, can you provide us with a typewritten transcript? Please assist in doing that. That helps a long way. Okay, the role of modern medicine today. Right now, this slide actually shows that in a modern medical team, you have, especially in a large hospital, you have huge teams dealing with different parts of patient care. But ultimately, the most important is the doctor and the nurse and any allied healthcare provider because they make the most contemporaneous notes. But those notes are then used by the discharge planner, the billing supervisor, insurance companies, who will then look at those notes and see whether they're done correctly and whether whatever they are billed for is correctly reflected, any reviewer or case manager. So while medicine has become more complex, ultimately the role of documenting lies with the doctors, nurses, and other allied healthcare providers. How and what do you document? That's the most important question. So a medical practitioner, nursing staff, or physiotherapist, whether it's occupational dietitian, speech therapist, any person involved in the management must make contemporaneous entries on the same continuation sheet in the medical records. So there is a continuation. Leaving blanks can actually do more harm because somebody may be able to come and put in entries. Entries that are put at the side also look quite suspicious, so they should be in a continuous fashion. It should be precise, legible, record the date and time and the procedure and treatment in chronological sequence, and should be signed by whichever party who is making the entry. Abbreviations and short forms which are traditionally accepted, like PRN, to come again, TCA, 1/52, up, down, symbols that are used very often, those are generally acceptable and they are recognized by other healthcare personnel. But if you have used your own abbreviations, it becomes very difficult because documentation also will assist or help whoever comes in to take over in the event you are not there. So the next person would be able to tell what treatment has been given. Past medical history, allergies, weight, height, blood pressure, pulse rate, occupation, all these are things that we normally see in medical records, which should be recorded. Presenting complaints, investigation findings, and treatment plans are also what should be stated in the medical records. And trust me, as a lawyer, the more comprehensive the medical records are, the easier it is for us to create or recreate that story when defending before a medical counsel or before a court. We've said this so many times as lawyers, document, but we also understand time constraints. But even if you do this, as long as the picture can be painted, that's what's important. So if you have given advice to the patient of more than one option, those options should be stated in brief. And in the end, what did the patient opt for? That is very important, because if the patient refused your advice, please note it down, get the patient to sign. Let's say a patient came in with signs of DVT. Admission was advised. Patient says, no, I don't want to be admitted. If they are going to be discharged against the advice of the doctor, it should be documented and signed. Similarly, if they're choosing an option which is not the option that the doctor has said to be the first option, it has to be documented that the first option not preferred to try this first. Or patient does not want conservative treatment and once goes straight to do some surgical procedure and give the reasons why. Because this would then help later when an expert looks at it to say, oh, why wasn't something conservative done first? These are things that are extremely important. Material risks and concerns, any comorbidities. This is especially so when you are documenting in a consent form. Consent forms, the risks can be documented even in your medical case notes. It is advisable, though, to have it countersigned, but documenting during the course of your contemporaneous records of the risk discussed is also acceptable. So if the patient declines advice or requests for investigations to be done on admission, please document them. Any requests by family members, contents or family discussions that may be held, because you may see the patient once, they might want to bring their family in, or they might not want to bring their family in. But if they do bring their family in, the gist of a family discussion should also be noted. Birth or treatment plans, if it's an OMG case, because that's something that you take time to discuss, but then you summarize it and write it in. Verbal orders, any verbal orders that are made should also be reduced in writing, because a lot of times doctors call and give verbal orders. Nurses document them. If it's done to a medical officer, medical officers need to document them. The times of phone calls, these are all important, because if the patient is starting to show symptoms and the nurse or anybody else calls the doctor, time should be documented as well, because there's all this issue about the time it took for the information relayed to the doctor and for the doctor to be in attendance becomes an issue. Next, appointments, further investigations, and any medical certificates issued. Why? Because when it comes to medical certificates, sometimes they may be issued for an ailment that the patient came for, which may be a flu and cough, and later on the patient may say, no, it was for leg pain. So if you could do this, it would help tremendously. Okay, what do you avoid at all costs? Strictly avoid entering any irrelevant, disparaging, derogatory, and offensive personal remarks about the patient or any other colleagues. Patients can be difficult. You may want to warn your colleagues that this patient is difficult, but please don't write it there, because one day, if those records are disclosed to the patient, that may be used against you, that you were judgmental of the patient. Erasure or any blackout of entries. Please make sure they are not black code, because that shows signs of wanting to conceal. They should be avoided. A straight line, an initial, and writing next to it, because we all make errors when documenting, and that's not wrong. In the computer, it's easy. You just backspace. But when it's doing manual records, that's very important. Please do not tamper with clinical case notes. Embellished records are frowned upon by courts. Why? It smells of a cover-up. And in the past couple of years, we have seen cases where, because of embellished records or doctoring of documentation, as they will call it, aggravated damages have been awarded against the doctors, because they would say this was a sign of wanting to cover up. So if, for example, patient is allergic to a medication and you still prescribe the medication, and then you cancel it later, that would be a cover-up, or perceived to be a cover-up. Okay, prescription of medication that the patient was allergic to. Okay, if it's given. Comments that is contrary to advice and investigations. So you don't want to write things like patient is bullheaded despite being told he needs to be admitted, he wants to go home. Don't write that. Just as patient opted to go home despite advice given over 15 minutes or something like that, and that would help you. Make entries in your insurance forms that come in later, which are not in your medical records, is a strictly no-no. Why? Because when that happens, courts and even your colleagues in the medical council will perceive that you did something that was not in the medical records. And where did you get this from? And if it's inconsistent, they would say that means your medical records were not complete. You don't want to go down that path. So these are things to avoid at all costs. So the consequences of this are that if they are ever disclosed, it becomes a point of embarrassment in court. You ask, doctor, do you normally judge your patients like this? Doctor, are you the kind who always deletes your records, who doesn't make accurate entries? And accurate entries are the milestone of good medical practice. So questions like this will be posed to you. So please avoid these pitfalls. Now, when disclosing medical records, normally the application for disclosure would come to the clinic or the hospital. They would have a procedure that's set out. Now, the procedure would require a written consent. The written consent would be that of the patient. And when the patient consents to a disclosure of the medical records, the originals are always retained by those who have custody, care, and control of the medical records, which is usually the hospital or the clinic. Photocopies or printouts are provided. But most times, on discharge summaries, bills, X-ray reports are usually given to the patient. And if they are given, there should be a note to say, patient given the following, and patient signs off on it. Because then you have records that if the patient ever said, I never had the X-ray films, there has to be a documentation to say it was given, because that is normal practice these days. So these are all the things to have in mind when disclosing medical records. Why? Okay, I'm going to go into some case law to tell you the legal position. Why? Because when you make good medical records, like happened in this case of Abdul Ghaffar against Pengarah Hospital Kapala Batas, Dr. Suhaila, who had attended to the patient, had left the country when the trial came. She left the country to do postgraduate studies, and she was beyond the seas, and it was not practicable to have her come back to attend the trial. So what happened in this case was the government of Malaysia there produced a letter to confirm that she would be away for an entire year. And if the defendants compelled, the court will have to secure it, but there would be high expense. What the court held in this case was, in the circumstances, the fact that she was away for a year in Australia doing her further studies, the court would agree with the defendant's submission that it was not reasonably practicable to have her come back. But pursuant to the Evidence Act, Section 73(a)(2), the court exercised its discretion and ruled that her entries in the medical records were admissible. Why? Because they were contemporaneous records of when Dr. Suhaila had examined and treated the deceased, and the existence of the fact was stated in there. And those entries were certified by the director of Hospital Kapala Batas to be part of the medical records. So this was a case where, with the medical records and the contemporaneous entries, the court excused the attendance of a doctor who was abroad. Today we have Zoom. I'm not sure it can happen today. This was 2010. Today, most likely, they would ask the doctor to attend by Zoom. But in the event that the doctor cannot attend for any reason, these are contemporaneous records. And the reason why this is important is, if you don't produce a relevant witness at trial, there is an adverse inference that can be drawn under Section 114G of the Evidence Act. And this is something that we'd like to avoid at all costs. So we'd like to bring all material witnesses before the court. In this particular case, the documentation saved the day. Now, the other reported cases that I'm going to go into, this is the case of Khoo Jia Xuan against government of Malaysia. It was an obstetric case. But I'm going to go into why accurate medical records are very important, because this judgment dealt with what happens when there's contradictions. And the judge held that his observation is fortified by the fact that oral evidence is not consistent with the notation in the contemporaneous records, in particular the neonatal record and the nursing notes. Instances of inconsistencies were cited. In all the circumstances, the court here found that the evidence of the nurses and doctors depart from the objective evidence of contemporaneous documents, and the oral evidence as a whole was therefore held to be unreliable and of no assistance to the court. So this is what happens when your documentation is different and you haven't recorded enough and you try to make up for it with oral evidence. If the gist is there and you elaborate, that's not a problem. But here it was totally inconsistent and it was not objective. And the judge also held that the contemporary documentary evidence in the appellant's own hand contradicted his viva voce testimony. That means his oral testimony. And the Court of Appeal agreed with the trial judge that the preferred contemporaneous documents, rather than the tenuous and tardy, unconvincing oral explanations given by the appellants on oath, would be the principles that the court would use. They rather have something that's contemporaneous, which is more believable, more objective, and more time sensitive. In the same case, Justice Wernanong also held that in situations where there are some contemporaneous records, the oral evidence of the witnesses must be tested. So if the witnesses come to court and say something totally against what is on the records, this would become facts that are disputed now. Why? Because contemporaneous records would be the so-called undisputed facts of what would probably the overall probability happened in that case, and more reliable to the courts. So this is why we emphasize on the need of documentation that is complete. I know it's quite impossible, but but I'm giving you all the instances as to why we ask for more documentation. The principle on which courts rely upon when dealing with records is this, and this is cited in the case of the Federal Court of Tindak Besar States, because they like to test the veracity of evidence. So in this case, Justice Chung Min Tat, as he then was in the federal court, said, he says, nevertheless, the trial judge expressed himself to be completely satisfied with the veracity of the respondent's witnesses and their evidence. He purportedly came to certain findings of facts on the oral evidence, but did not notice or consider that the respondent's oral evidence openly clashed with the contemporaneous documentary evidence. For myself, I rely in the acts and deeds of witnesses which are contemporaneous with the events to draw reasonable inferences from them, than to believe their subsequent recollection of it or version of it, particularly if he's a witness with a purpose of his own to serve, and it did not account for statements in the documents and writings. Judicial perception of the evidence requires oral evidence to be critically assessed against the whole of the other evidence and circumstances of the case. He ended with saying, plausibility should not be mistaken for veracity. So while it may be plausible, verification with contemporaneous records was the ultimate aim. And this is following the case of Grace Shipping Incorporated, where Lord Gough, in a Privy Council case, says that when a judge is faced with the task of assessing the evidence of witnesses about telephone conversations 5 years before, memories can become unreliable. It's crucial of importance for the judge to take into account contemporary documents and the overall probabilities. Now, this is why they say it's the test of veracity with objective facts. They can test the credibility of witness that you wrote this then and you're saying something else now. I don't know about others, but sometimes I don't even remember what happened 4 weeks ago unless I've written it down. So this is what the court is testing you on. Trials often take a year or more before a trial comes to court. Suits are filed sometimes 5 years after the event happens, sometimes longer than that. And by the time it comes to court, it would have been years. So the overall probabilities and of a contemporaneous record is of great assistance to even a judge when ascertaining the truth. So when you have these sort of principles that have already been set out, the importance of documentation becomes even more compelling. And I know this is not taught in medical school as to the risk management of what happens, but this is why documentation is extremely important. I'm now going to go into a case which was not a medical negligence case. It was actually a breach of contract case. It was a case against London Weight Management Clinic by a dissatisfied customer. The customer was dissatisfied because she felt that she started feeling ill with the package that she had taken at this London Weight Management Clinic. She sued for breach of contract. The High Court found against her and found that there was no liability for breach of contract. The Court of Appeal in 2019 reversed that decision. And why? Why did the Court of Appeal reverse that decision? The Court of Appeal actually went into the evidence, and the Court of Appeal said, in light of the defense and the position taken at trial, the respondent's single witness, that means from the weight management clinic, who was a supervisor who had given, of the branch that had given the package to the patient, cannot be reliable, and says this, that DW1 had no personal knowledge of matters complained of. Giving evidence from records was of no real assistance to the court. She was unable to provide any evidence on the appellant's complaints since she had none of the requisite knowledge. Her evidence was thus should have been disregarded. So when there was only a single witness the supervisor who was giving the evidence, the court said, no, we can't rely on that. And by comparison, the appellant's evidence was supported by both documentary and oral testimony because she was a patient herself. And one such testimony came from a Dr. Gunn, PW3, who was a consultant physician and gastroenterologist that saw her for the complaints and learned. And one of the reasons why the learned judge found the claim was not proven was because they requested a letter from him saying that that whatever effects of the treatment that had been given, he had refused. The request was actually recorded in the patient's notes. And it was recorded and it's highlighted in red. The recording said, patient requested for a letter saying she's suffering from the effects of the treatment of London weight management, told her that that would be a very strong accusation that I will have to show evidence, but there is none. So the best I would do is to say she should not continue with the program. This was the documentation of the gastroenterologist in the records. And the courts took that view and said, it's our respectful view that it was erroneous of the judge, the trial judge, not to take into account that this was recorded by Dr. Gunn, who came to court. And then for him to evaluate and disregard this evidence outright. So these contemporaneous records swung the case to the favor of the plaintiff, and the plaintiff was then given judgment in her favor in the Court of Appeal. This is a different case, the case of Dr. Pramita against, and this was the appeal against Gurisha Taranjit Kaur. Now, in this particular case, this baby was born with shoulder dystocia. There was a huge debate in the trial court as to whether there was adequate counseling of whether this mother, who had a rather big baby, should have been counseled about the fact that a C-section should have been given to her. Now, the High Court had found against the doctor and entered judgment. At the Court of Appeal, this was reversed, and it was reversed on a careful perusal of all the evidence. And this is what the Court of Appeal judge said. A careful perusal of the trial judge grounds of judgment showed that the process of reasoning adopted by the judge for preferring the evidence of the plaintiff witnesses was based on a wrong premise and not the well-accorded principles that would form the fulcrum of the scales of which justice turns. The trial judge's conclusion went also against the grain of evidence. It was the duty to intervene because they then went to say there was ample evidence to support Dr. PD's contention that she had discussed the option of a cesarean section, and even the patient had a day before admission sent a WhatsApp. So these were all documents and contemporaneous documents that were used at the trial. Now, the Court of Appeal looked at it and said the contemporaneous documentary evidence showed that Dr. PD had discussed the option of a C-section with the patient during the latest antenatal visits, and there was also WhatsApp text messages on the subject between her the day before admission and induction of labor. It also showed, the notes also showed that the patient was not in favor of a C-section and preferred a normal vaginal delivery by induction. So therefore, the judge misdirected herself to say that it was never discussed with the patient. This turned the case, and then liability was reversed and the claim against the doctor was dismissed. Now, I know doctors will always come and say, it's impossible to record everything, and sometimes we are examining the patient. So it's about taking a moment after that to do it. Even in emergency situations, the golden rule is focus on the patient, do everything that's right. Late entries are allowed. And this is actually said in the case of Zul Hasnima by the trial judge at the High Court. She actually said this. She said, there are times when doctors' notes were written after procedures were completed. These then become their recollections of events that had taken place. Failure to note events and procedures in minute details could be excused. So see, the judges understand that your duty is to save the life first. You document later, and minute details will be excused. Variance in time was likely to occur in emergencies, and it was therefore not unreasonable for time recorded to be inexact. It would not be wrong to surmise that all doctors testifying in the trial were in the chorus that entries by the nurses and doctors were approximations, emergency records of time entries that were made after the event. And more important consideration was to look at the effect and the management of the patient in itself. So while accuracy can help, but late entries are also something that courts understand. Okay, this is a recent case in 2023 in the case of Dylan Analalaki Satyamuthi against Gleneagles Hospital and a few others. It was a case where the patient had come in with an ankle problem. There was an orthopedic surgeon involved, and there was an infection, and there was a plastic surgeon that also came in. Now, when it came to the documentation of risks suggested, there was no liability found against the orthopedic surgeon. And why? This is what the judge had to say. As pointed out by plaintiff's counsel, the court must consider contemporaneous documents and should put more weight on these documents rather than recollections. Therefore, I find that Dr. Chan did undertake the appropriate steps to ensure that all relevant information and options were made available to the plaintiff before treatment was undertaken. He did not rush into surgery and did try to see whether the said treatment could be treated naturally. I also note that the plaintiff contends that he was not told of the risks involved in the surgery by Dr. Chan and the proposed treatment. I believe the picture painted by the plaintiff is untrue, and the version of events suggested by Dr. Chan is correct. The contemporaneous documents of Dr. Chan, as recorded in the consent form, indicate to me that it is more likely than not that the risk factors and the options available to the plaintiff were explained with care to Dr. Chan. So that was a finding made based on contemporaneous documents. So again, contemporaneous documents save the day. So I'm going to conclude now with final tips and takeaway. Whenever recording, please have consistent contemporaneous documents because it clearly saves the day. Back it up by investigation. If you have done any physical investigation, if you have looked at flexion, extension, if you have examined any foot for the same, if you have looked out for any swelling, even if you put swelling nil, that helps. Material risks in consent forms have to be documented and preferably countersigned, even if it's in the medical records. Follow a treatment plan, and if deviating from a treatment plan that has been initially agreed with the patient, please document why. Please also use common abbreviations and not abbreviations that are not known. Why? Because a PID to an orthopedic and to an obstetrician or to internal medicine is quite different. Your notes are what the court, lawyers, and experts will use. Help yourself so that this will help everybody else. Nurses and allied health professionals' notes are always contemporaneous, and they would usually be your checklist. So many times when they make a checklist of what the patient was feeling before the patient went to OT, whether the patient was well, whether the patient had signed the consent. Now, these become extremely important when it comes to going to justify that the patient knew what was happening. Keep up with developments, because what happens when you keep up with developments is then you realize how the courts have found when it comes to documentation. Enlist colleagues to come in if required, and please put the referral down. And when you put a referral down, there is then a sequence of events. Video and audio recordings, when they need to be recorded and put in the medical records, please ensure that happens. We have had cases where the machine is not working. Doctors start taking video recordings, audio recordings on their cameras in their phone. When that happens, please ensure that it's given to the medical records department so that it can be put in as entries and so that they are contemporaneous, because those would be equally important. Otherwise, when we want to look at what has happened, let's say in an angiogram or in an ERCP or in an X-ray, you go back to the films, you go back to the recordings, and this is what becomes absolutely important. If there has been a video recording or audio recording, if even a consent taking, some doctors opt to do that. they put it down. Please make sure it's immediately recorded with the consent of the patient and put it in the medical records. Dates and times of attendees are as important. Please do not alter or embellish records, and late entries, as I've shown you, are allowed, provided they are put in as late entries. So that is a summary of my talk today, and I leave it to you to now decide to document or not to document. That is the question you will answer today.
Thank you very much, Datin, for your excellent presentation on this very important topic. And we've now reached the Q&A session, and I'd like to invite Datin Anit to the stage. And let's see if there are any questions on Slido at the moment. I can't see, but there are some. Okay, we've got some echo, sorry. All right, there's some questions on our YouTube. John Doe asked this question. How do you reconcile judicial expectations of thorough documentation versus practical limitations faced by clinicians in high-stress, fast-paced environment?
I actually do think that doctors do work in a very intensive situation most times, and courts are pretty sympathetic to that. So as long as you have recorded what is enough to paint a picture, generally the courts do find, like one or two of my slides did show, that the priority is to treat the patient and then to make a late entry when you have the time a bit later.
Yeah.
Alan, don't you think there are some other tools now that are available to doctors to assist documentation?
Yeah, actually, one of our previous webinars, one lawyer suggested you should record everything, you know, audio, maybe visual, but actually you end up with a huge amount of data and may not be practical. Yes. Yeah. So, but in lieu of this, now with modern technology, we have something called ambient scribes. So actually, there are tools, software tools, which can take audio recordings of your dictation and in fact, even conversations between you and your patient, and then transcribe this into even a one, not just word by word transcription, but actually it formulates a progress note for you to manually edit, correct, and then copy and paste into your medical records. This actually has saved a lot of time. We'll go through the other discussions, but I've been using ambient AI scribe for dictating my clinical progress notes, either in the clinic or in ward rounds, and I can tell you it's a game changer. It's a life-changing tool, which almost every doctor, if you don't know how wonderful it is, you're missing out on a lot. I'll show this later. Maybe if you've got time, I'll even demo it. Okay, we will go through the other questions first. A lot of questions from John Doe. He's our regular participant and also throws us, our presenters with a string of questions. So how can clinicians identify and mitigate implicit biases in their documentation? Especially
we don't imply implicit biases unless something is pretty blatantly recorded. So if it's not recorded, they don't assume anything unless someone comes to court and says, "Oh, the doctor said this to me," and then it becomes a he says versus she says, and then the court has to decide who to believe. So unless you write something which is derogatory, we don't actually identify any biases at all.
Sometimes in such situations where I feel that there may be some acceptance or understanding issues in the patients, sometimes it's worthwhile getting a nurse to also sit in and also
definitely
be a witness, I think, to such situations. And also they can
and
document.
And a
Yeah.
translator when required, because sometimes it's a
Yeah.
question of
Yeah.
understanding.
Yeah. Sometimes the way we talk, it may be over the head of the patient, and they may
Oh,
actually have
yes.
problems with understanding. Yeah. Yeah.
Oh,
And there's another
trust me,
important.
doctors use a lot of medical jargon sometimes that
Yeah.
as lay people we find it difficult to understand.
This one is interesting question. How do you approach documentation in cases of complex ethical dilemmas, such as end of life care, when there are differing opinions, especially among family members, patients, and doctors? Actually, this was discussed in our forums about advanced care directives. You say
Yeah.
the patient may have given an advanced care directive. And what if another relative comes out of the woodwork and says, "No, I don't want. I want you, the doctor, to do everything to save my mother, even though she's got terminal cancer. I want you know, I don't think you should follow her directive. We want you to do this and that." And what is your opinion?
Well, my colleagues and I at the Medicolegal Society Malaysia have been pushing very hard to have legislation in place with the Mental Capacity Act and Advanced Care Directives to be part of law, which is not currently in Malaysia. So in Singapore, this is law. So if you have left an Advanced Care Directive, it's going to be followed. In Malaysia, it's not. So it's then becomes up to the clinician who is faced with the problem, faced with the competing interests of different family members, and then doing what he or she would think would be in the best interest of the patient. It then becomes a real dilemma. Documentation would be to say there is an advanced care directive. This family member has decided or come to see me. We will call a family conference. And a lot of times we have great issues because in today's society, you have children who are based abroad, and then you don't have immediate family members in the country. And then you may have to have a Zoom call, and it becomes more difficult than you may think unless someone is appointed. So I really hope and pray that the advocacy for a Mental Capacity Act and Advanced Care Directives actually materializes in Malaysia, because it will make life easier for most clinicians as well. So currently, I do empathize with doctors and clinicians when having to deal with these things. These are extremely important issues. They have become even more important since COVID, and I just hope that there will be a resolution legally soon, because currently
Yeah.
it's not regulated.
Yeah, we hope so too. There's another topic, another question about how do we handle situations when there's conflict between clinical judgment and institutional protocols, and how to document this in a way that protects both physicians and patients.
Actually, it should be patient's interest that is paramount. I wouldn't emphasize on institutional protocols. It would be patient's interest and what the patient needs, because your Hippocrates oath prescribes that you treat the patient according to the ailments and what they need, and that should be priority. And if there is anything impeding it, some discussion should be held with any party that can help smoothen it. But clinicians have to do what is right, and usually they
Yeah,
do.
point well noted. Point well noted. Number one is patient's interests come first. Okay.
Yes.
One more question from John Doe. I think you've covered this, but no harm repeating it for those who didn't get it earlier. When there's an omission or error in documentation discovered after the fact, how should such retroactive amendments be handled to avoid both legal exposure and ethical concerns?
I think a late entry to state why, like an addendum, and it is only if at the time of discovery, to say just discovered, this has happened, or a new investigation has identified this, so now the plan of treatment would change. That can be done, and it is really then up to the clinician. No
Yeah, but I think
obliteration, though.
Yeah, as you
cancellation with
said,
the initial at the side.
do not blanco it off. You may
Yes, don't obliterate.
scratch it and sign, or we don't have to scratch it off. So we just add another note as a follow up
Yes,
to that note, and then clarify. Oh, I didn't mean that was an error or miss spelling or something, and then we're going to
yes.
clarify that. Yeah. Okay. Uh, we got a question.
There's one. Mhm.
One more. Straightforward question. How reliable are WhatsApp communication texts when it comes to medical legal cases? So, I mean, you referred to that one where there was WhatsApp
Yes,
communication was taken as
correct.
a contemporaneous evidence and documentation.
So the courts do rely on WhatsApp conversations. A lot of times they are exported and printed in court and produced to say this was the sequence of conversation, and it becomes part of the what happened at that time. The courts do look at it favorably as long as nobody denies that it has been tampered with. So you've seen a case that I illustrated where WhatsApp conversation was used. In fact, we have also a case where a thumbs up on a contract was meant to be acceptance. So in a medical legal context, if a doctor gives
Wow.
if a doctor gives a patient two options and says, "Oh, you've got option to do A or B," and patient says B, and I will come in tomorrow, that will deem to be acceptance of option B and the fact that the patient has agreed and will come in the next day. So this is all things that do happen because they are recognized modes of communication in today's world.
But there are some issue with WhatsApp because they can be deleted, isn't it? Unlike
Yes,
proper secure communications used for medical grade, you can't delete it. Yeah, they're actually archived, and there is a trail, electronic trail.
yes.
Even electronic medical records, you can't actually delete. You can
No,
amend,
you
but the
can.
trail is there.
Yeah, if
Yeah.
the trail is always there. So your systems
So
are
how?
in place, but but this depends. If it's usually when it comes to WhatsApp conversations as well, when they're printed out, they're put to the witness during cross examination and said, "Do you agree this was sent to you? And do you agree this happened?" If the witness agrees, then they become contemporaneous documents.
Okay, yeah. So as long as it's not been deleted by both parties and it's still
Yes,
traceable, so they can be
yes,
used. Okay.
according to sequence.
Yeah. Dr. Rohini asks, how much weight do courts give to recordings by one party without the consent of the other? Let's say a patient secretly records.
Okay, these recordings are admissible, but the weight would depend on the facts and circumstances and how the cross examination happens. So I cannot give you a straightforward answer, but the court determines the weight, and the weight would be determined after cross examination, after the fact that did you tell the doctor that it was being recorded? Did the doctor say this in context? Is this recording actually original? Is it tampered with? So there are lots of series of questions that are usually asked, and then the court decides how much weight to give it and whether in those conversations somebody is meant to be joking, or it's said in a laughing voice or it's said in a serious voice, what sort of discussion it is. All that will have a bearing on how the court decides, but I cannot give you a hard and fast answer on how much weight the court will give. It depends on each particular circumstance.
Okay. So they're potentially admissible. Yeah.
Yes, they
Okay.
are.
All right. Let me check the. Yeah, there's no questions on Slido, but that while we are waiting for more questions to come in from WhatsApp, maybe I'll demonstrate the life-changing AI medical scribe for you guys who are attending. And the the application which I've been using is called Heidi Health. It is a AI ambient scribe. So what it does is allows you to take your dictation as well as record any conversations between you and your patient, and then transcribes it into a proper medical format. Typically, it's a SOAP, which is subjective, objective assessment and plan. Um, if you want to sign up for free, and actually there's a free tier. This is an Australian company who came up with Heidi, and you can actually use it indefinitely for free. It's just that the pro features require subscription, but I can tell you even without the pro features, it's fine. And you can use the basic SOAP format unless you want special templates, etc. That's more for really professional, heavy users of Heidi. But it works very well. And let me see if I can demo it for you. I was going to get Anit to be my patient, but I'm not sure whether you'll be able to pick up the voice.
Let's
so
try.
What I'm going to try, or I was going to use. I have now advanced voice mode on my ChatGPT, so I'm going to get ChatGPT to be my patient
great.
and see that works. All right, so that we won't involve Anit. First time I'm using this, so we'll see. Hello, ChatGPT. How are you?
Hi, Alan. I'm doing well. Thank you. How about you?
I'm well. Listen, I'm going to actually demonstrate an AI dictation or scribe application. I wonder whether you can pretend to be my patient.
Absolutely, Alan. I'd be happy to help. What kind of scenario are we looking at for your demonstration?
Okay, I'll be the doctor, and then you'll pretend to be my patient coming to the clinic. Is that all right?
Sounds perfect. I'm ready. Okay. My guidelines won't let me talk about that. Can I help you with something else?
Okay, anyway, you're my patient, and now you've come to my clinic. So I'll say, I'm Dr. Allen. How can I help you?
Hi, Dr. Allen. I've been feeling really tired lately, and I've noticed some unusual bruising on my arms and legs. It seems to happen without any injury. I'm a bit worried.
How long have you had the bruising?
It started about 2 weeks ago. At first, it was just a couple of small spots, but now there are more and they're larger.
All right. Have you noticed any bleeding from your nose or gums or elsewhere?
No, I haven't had any nosebleeds or gum bleeding. It's just the bruising and the fatigue that's been bothering me. And I've also been... Is there anything else you'd like to know, Dr. Allen?
Okay, looks like the connection was lost there. But anyway, have you had any fever, body aches, or any other symptoms?
No fever or body aches, just the fatigue and bruising. I haven't noticed any other symptoms.
Okay, so I'm going to perform a quick physical examination. I notice you're a little pale. You have some enlarged lymph nodes in the neck. Your spleen is enlarged. Let's run a quick full blood count. Okay, and in a miraculous 30 seconds later, the full blood count comes out. If your hemoglobin is 7.4 grams per deciliter, your platelet count is 15, and your white cell count is 50,000. So we'll have to look at the blood film because this is something quite unusual and may point to marrow pathology. And it's likely you will need a bone marrow examination, and that will be the immediate plan, and you'll likely need admission. So I will stop the transcribing here. You can see on the upper right, there's a transcribe button while all the recording is happening. Okay.
Got it. That sounds like a solid plan, Dr. Allen. Would you like any feedback on the demonstration?
No, thank you. All right, thank you, ChatGPT. Goodbye. So you can see the AI scribe has put it into subjective, objective, even recorded everything, and the plan. How much typing did I actually have to do? Practically zero. Do you get it?
How amazing is that? We should be dictating our submissions.
No, in fact, this is not just for doctors. They've targeted at healthcare practitioners, even nurses, physiotherapists, counselors. Actually, basically, it just documents your encounter for you. You know, imagine if I'm just seeing the patient, I can just be with the patient, talking with the patient. I don't have to type, type, you know. And I'm quite a fast typist. And I can tell you this application saves at least 30 minutes of my typing every morning in the clinic. It's really, really life-changing for me. How much time it saves. And if you guys want to try it, it's completely free to try. Just go to HeidiHealth.com. But if that's too long for you, I've created a shortcut, dobbs.my/Heidi. That will take you to the page. You can sign up for free. It's zero cost. Sign up, they will take you through a sample case, and then, you know, it's actually quite easy to use. And then what you do is you can also, if you have a microphone in your desktop clinic, that would be ideal. Or you can also install you look for Heidi AI Scribe in your App Store or Google Play Store. It's now available, as well as a mobile app. And then you can download, sign in there. And you can use your phone, as I did, as a microphone. And you can load the same thing on your desktop PC, and then whatever is transcribed on your phone also will be reflected onto since it's a web app, it will be reflected on the screen like this. Yeah. So you can do this for clinics, you can do this for ward rounds. Yes.
After this is transcribed, you literally copy paste and put it into the electronic medical records.
You can see they put a caution there in yellow at the top. Review your note before use to ensure it is accurately represents the visit.
Okay.
So in fact, you should do that, because nothing is 100%. I would say it's like 95%. It's eerily accurate, you know, and it's very, very fast. So I don't know what magic, but it's AI magic in the background. Last time we used to do things like use apps like Dragon Dictate, where it has to be, you know, people get frustrated because it doesn't correctly recognize what we are speaking. But it doesn't matter. It's got it has what they call AI behind to actually understand what you're trying to say. So you know. John has some questions about Heidi Health. Actually, there's no private patient data. If you notice, you don't.
Yes,
there's no name. There's no identification. It's actually nothing. So actually, there's nothing. Yeah. So there's nothing to breach in terms of patient data. However, if you go through the Heidi FAQ, they advise you to take consent, inform the patient that you're using this AI dictation tool, but assure them that none of your data is going to the cloud. It's just the text, which comes out as a transcription. Emergency. No, I mean, it's nothing to do with emergency. It's just even in emergency room, I've used it as well, but it's just to help me quickly make the clinical notes, you know, rather than type, because it's so much faster, I can tell you. And it saves a lot of time. If you're writing letters, there's also a dictate. This is a transcription mode for clinic encounters. There's also a dictate mode, so you can actually dictate your letter, and you can just jumble up everything here and there, but you arrange everything for you very nicely in a letter format. I can tell you just got to try it. So if you have not, Raj says game changer. Give it a try. You won't.
It's legible too, so it will be great for us.
Yeah. Well, doctors will wonder if it's so. If you work with languages such as Fuzhou, Hokkien, Bahasa, Malaysia, Tamil, etc. Now, there is some drawback with Heidi. It works only with one language at a time for one encounter. So you can't mix up languages. However, it can recognize Malay, it can recognize Hindi, it can recognize Cantonese and Mandarin. But all the conversation has to be in that language. All right. So if I'm meeting a patient and talking in Cantonese and a patient replies in Cantonese, it will understand. But if you mix it up with Malay and then in English, that's where there will be gaps in the recording. You can still record, but it may miss out things. But it doesn't really matter. Actually, you at the end of the day, it's up to you to go through it and then fill in. So it's a marvelous tool. Eventually, I think it may have multilingual support within the same encounter. But at the moment, it's only one language per encounter. But there's no time limit, so you can be like half an hour clinic encounter, or even for our psychiatrists, they give 45 minutes per patient. They say, oh no, so much to document. This is the godsend for them. You can have a 45-minute session with your patient, and it's all your documentation will be a breeze after that. So
Thank
I mean,
you for
just give it a
sharing
try.
this.
No, yeah, it's a marvelous tool. I have no shares in Heidi, but I'm a user, and I'm very tempted to try Pro for free, but let's see how it goes after a bit more as well, because the Pro will give you the option for putting templates, because some surgeons may want a template for urology or liver surgery or something, so it will format it differently rather than just the simple SOAP format. Yeah. Okay, I think I rambled on long enough. We've gone past an hour, and we'll need to move on to the most important bit of this session, which is actually the CPD points. Yeah. So to claim points, the dentists have already got a pre-registration form, dobbs.my/dentist0924. For the doctors who have been kind enough to stay on right to the end, this is the link to the our registration form for the doctors. This QR code is not meant to be the MMA code. That MMA code for scanning is no longer applicable for online events. This, if you use your camera or QR code, it will take you to this very same link, the dobbs.my/250924. All right, it will take you to a Google form, and please fill in your attendance by your name, and most important, get your IC right, because the CPD point is recorded by your IC number. All right, and the link will expire at midnight tonight, so to prevent abuse of the form, I will be able to give you points provided you make a comment to the video after tomorrow that you've watched it, and then we'll WhatsApp you for further instructions on how to get the point for just simply watching. So I think I'd like to thank everybody for participating and all your insightful questions, especially John Doe as usual. And last but not least, Datin Anikor, thank you for the very insightful talk. Yeah, on medical documentations.
Thank you for having
Yes.
me. Bye.
Yeah. Right. So did the form work for everybody? The last month I made a boo-boo. The form was not active. So I think did everybody get it? Anybody manage to submit? Yeah. Can give confirmation in the YouTube comments. Okay, no problems. All right. Okay, yeah, form is fine. Junkin says thank you. Zafir says form active. Excellent. So, all right, I wish everybody good night. I mean, even if you caught this stream late, you can still watch right to the end, and you can still fill in the form right until 12 midnight tonight. After 12 midnight, like Cinderella, the thing will no longer work. And you'll have to claim points by making a comment in the YouTube video that to just certify that you've watched it, okay? And we'll take it from there. All right, so I'm going to end the live stream. Thank you everyone for participating. Please don't forget to try out Heidi, game changer, life changer. You have more time for golf or whatever you want to do in your spare time. So thank you. And you make the lawyers work easier because, yeah, your documentation will be very accurate. Let me tell you, sometimes I can't remember when I see the patient in the ward, we talk about this, and then document. Then when I come back and sit down in the front of the PC, when the Heidi will tell me, oh, we talked about this, and actually I've forgotten, if I've not used it, I would have forgotten to document certain things. So actually it really helps, especially as we get older, something the gray cells are not functioning so well. We really need these kind of tools. I wish I had it when I was younger, 30 years ago, but that technology was not available. It's here and now. Make use of it.
Yes.
Yeah, it's
Living
amazing.
in exciting times, and
Yeah,
whatever can
yeah,
make things easier and make medicine seamless should be good.
yeah. Anything to improve efficiency, I think, and especially make our documentation more complete. I think we have issues with every hospital. I don't want to say any particular specialty, but some specialties will just put there for appendectomy. That's the documentation. No, I'm sure there are many surgeons who will document thoroughly, but there are some issues like that. It's difficult. Not everybody can type, and some people just hate computers. Okay, so thank you everyone, and I wish you everybody good night, and thank you, Datin Anit. All right, we'll
Thank
end the
you.
stream now. Yeah.